What if a missing pair of pants sparked a $54 million courtroom battle? Or a guy dragged God into court, only for the divine to skip the hearing? That's pure mayhem, yet, out of such wild disorder, real laws sometimes emerge. The justice system is meant to be a stronghold of reason, but occasionally, a case so ridiculously foolish smashes through, pushing lawmakers to craft fresh rules to prevent repeats. Let's dive into those outrageous trials that birthed our weirdest regulations. First off, the crown jewel of silly suits, the infamous $54 million trousers fiasco. Back in 2005, Roy Pearson, a judge from Washington, D.C., dropped off his pants at a neighborhood dry cleaner, and they vanished. Most folks would grumble and move on. But Pearson, who judged cases for a living, saw it as a catastrophe deserving a fortune rivaling a tiny nation's budget. His reasoning: the shop's satisfaction guaranteed sign was like an ironclad promise, worth a massive windfall. The battle raged for years, almost ruining the immigrant owners' lives. Pearson lost in the end, but his over-the-top grudge match shamed the nation. It pushed courts to tighten up on baseless claims, basically enacting a rule that screams, you can't bankrupt someone over misplaced laundry. A much-needed update, especially ironic coming from a judge who should have known better. Second, in 2007, Nebraska Senator Ernie Chambers went big, really big. He launched a lawsuit against none other than God himself. That's right, the all-powerful creator. Chambers wanted a court order to halt divine disasters like killer floods and savage storms. Shockingly, the judge didn't laugh it off right away. They actually considered it briefly. It got tossed not for being wildly illogical, but on a technicality. How do you deliver papers to an invisible being? No address on file. This sparked a quirky Nebraska rule. Suing the universe's boss is hypothetically doable, but it'll crash on delivery issues. God stays unbeaten not by holy power, but by dodging the mailman. Third, Virginia prisoner Robert Lee Brock cooked up a genius plan. He decided to take himself to court for $5 million. His angle: by boozing up and breaking laws, he'd trampled his own rights and faith. The clever twist: as a broke inmate, he insisted the state foot the bill to him. The judge shut it down with epic poise, highlighting the absurd loop. This wasn't justice. It was a mind-twisting riddle, now a law school staple. It locked in the idea that courts aren't for self-sabotaging money grabs. Fourth, patterns emerge, don't they? Courts face constant assaults from wildly inventive nonsense, but when it crosses borders, enter 2008. The mayor of Batman, Turkey, threatened to sue Warner Brothers and filmmaker Christopher Nolan. Why? They stole his city's name for the Dark Knight movies without asking. He blamed it for locals' mental anguish and rising crime. As if Gotham's chaos leaked into reality, the suit fizzled before trial, turning into worldwide mockery. It didn't make official law, but it birthed an unspoken global guideline. Don't pick fights with blockbuster icons like Batman. It's a recipe for ridicule. Fifth, in 1997, a self-proclaimed psychic hauled NASA into court for $300 million. Her beef: the Mars rover was invading her turf, Mars itself. As Earth's Martian rep, she said the robot wrecked the planet's energy vibes. Messing with her powers, dismissed in a flash, it quietly set a rule: to sue in America, you better hail from this planet. Apologies to aliens, no standing here. Sixth, iced coffee that's mostly ice? Annoying, sure, but one Chicago lady turned it into a $5 million federal showdown with Starbucks. Her point: a 24-ounce drink isn't truly 24 ounces. If ice hogs half the space, pure scam. The judge nixed it, noting even kids grasp that ice takes up room. This boosted the reasonable buyer rule, saying laws don't shield you from basic science. Seventh, in the 90s, Richard Overton slapped Anheuser-Busch with a $10,000 suit over Bud Light ads. The spots showed dudes popping beers on beaches, summoning gorgeous women like magic. Overton said it was a lie. He drank plenty, but no paradise or ladies appeared. He wanted cash for the letdown. Court said no, cementing puffery as a defense. Overblown ad hype isn't a promise. That's why you can't sue for not sprouting wings from energy drinks. Eighth, courts usually squash this stuff quick, but for serial filers, California's got a fix. Slap 'em with vexatious litigant status. Born from folks flooding dockets with junk suits. It bars new cases without judge approval. Applied to a guy who spun one fender bender into 300 claims against everyone involved. It's like a Cortisha gag order for lawsuit addicts. 9th, a Michigan man scored a Subway for life prize, then sued over it, expecting endless subs forever. He got gift cards worth $13,000 instead. He cried foul on for life. Court-backed Subway, letting companies set their own prize rules. Saved us from winners draining firms dry with lifetime freebies. 10th, the McDonald's coffee saga is everyone's dumb lawsuit example, but it's misunderstood. In 1992, elderly Stella Liebeck got severe burns from ultra-hot coffee needing grafts. McD's brew was scalding hot, and they ignored 700 prior complaints. The big payout punished negligence, not clumsiness. McD's PR twisted her into a greedy villain, but it strengthened corporate accountability laws. 11th, a monkey stole a camera, snapped a viral selfie, and chaos ensued. PETA sued for the macaque named Naruto, saying he owned the photo rights. It reached appeals court. Can animals copyright? No, ruled the judges, updating rules to exclude non-human creators like apes or spirits. A simian snap reshaped IP law. 12th, Portland's Alan Heckard demanded $832 million from Michael Jordan and Nike. Crime? He resembled Jordan too much, leading to constant mix-ups and stress. He couldn't escape the fame without the fortune. Dropped eventually, but it nailed down. You can't sue for looking like someone famous. Your face isn't suable property. 13th, Fruit Loops have no fruit. Shocking? A California guy thought so, suing Kellogg's in 2009 for tricking him into thinking it was healthy. Judge laughed it off. The goofy spelling screams not real. Bolstered smart shopper. Rules laws don't babysit obvious fakes. 14th, some cases turned dark. In 1981, Arn Johnson killed his landlord and blamed demonic possession. The devil forced me. His team argued. Judge rejected it as unprovable nonsense, set a firm bar. Supernatural excuses don't fly in U.S. courts. 15th, magic shows promise tricks, not trips. A Brit at David Copperfield's Vegas act joined a vanishing illusion, slipped in hidden halls, and got hurt. He sued, forcing Copperfield to spill the secrets in court. Magician won, but it set rules on participant risks while ruining the mysteries. 16th, we all gripe at parents, but a New York 28-year-old sued his for $200,000 over bad parenting. Not enough love, he said. Left him jobless and miserable. Court shut it down fast. No enforceable good parent standard. Protected families from turning grudges into lawsuits. 17th, wrong weather prediction. Sue, an Israeli woman did, after dressing for sun and getting rained on. Catching flu. She won $1,000, asterisk globally. It pushed forecasters to use chance of phrasing for legal cover against nature's whims. 18th, BMW's cruise-like throttle let a rider hands-free until he crashed grabbing his bag. He sued for no warning, dismissed. But it explains why products warn against the obvious, like not ironing on your body. 19th, haunted houses scared a universal visitor fainted from fright, broke her wrist, and sued for too scary. Court said no. Buying in means accepting the fear. Assumption of risk now shields thrill attractions. 20th, a short foot-long Subway sub sparked a viral lawsuit frenzy. Lawyers cashed in millions. Customers got zilch. Highlighted class action abuses, fueling reform talks. 20-1st, Dan White's 1978 murders of San Francisco officials used the Twinkie defense, junk food as depression sign for leniency. Public rage killed diminished capacity in California law. Snack myth rewrote murder defenses. 20-2nd, Pepsi's points promo joked about a Harrier jet for millions of points. A student raised cash and demanded it. Court said ads aren't contracts. Defined hype versus promises in law. 20-3rd, is a burrito a sandwich? Panera sued Qdoba over mall exclusivity. Judge said no, based on fillings and eating style. Influences food contracts nationwide. 20-4th, Mariah Carey's brother sued over her memoir's portrayal. Court protected personal stories as opinions. Safeguards memoir writers. 20-5th. Leona Helmsley willed $12 million to her dog. Snubbing grandkids. They sued. Dog got $2 million. Popularized pet trusts in law. 20-6th. Burglar injury suits, mostly myths, led to castle doctrine laws. Homeowners now immune from intruder claims. 20-7th. The fake Winnebago cruise control tale explains absurd warnings. Fear of suits drives defensive labels. 20-8th. Harley tried trademarking their engine sound. Failed after battles. Can't own functional noises. 29th. A gambler lost $500,000 drunk and sued the casino. Court said casinos aren't babysitters. Protects the industry. 30th. Captain Crunch's berries aren't real, sued for deception. Dismissed, obvious to anyone. 30-1st. Red Bull gives wings. Sued for no flight. Settled big. Showing specific claims can force payouts. 30-2nd. Happy Birthday was copyrighted aggressively. Lawsuit freed it to public domain. 30-3rd. A sleeping fan sued ESPN for mocking him. Dismissed. Broadcasters can comment on crowds. 34th. Adele user sued over bad Indian support. Settled. Warning firms on outsourcing risks. 35th. A weather anchor joked a viewer looked like a gorilla. Sued and lost $500,000. Jokes can defame. 30-6th. Creed fans sued over a drunk singer's flop show. Dismissed. No quality guarantee for concerts. 30-7th. Sock puppet ads sparked a copycat suit. Ruled. Can't copyright broad ideas. 30-8th. A Brazilian wife sued her husband's mistress for heartbreak. $160,000. Rare in U.S., but highlights emotional damage claims. 39th. A Cowboys fan sued NFL over a bad ref call. Dismissed. No suing over game outcomes. 40th. ES lip balm caused blisters. Viral suit settled. Showed social media's power over courts. 41st. The not sued the but for similarity. 1. Parodies can't confuse. 40-2nd. Drive trailers action hype versus artsy film led to suit. Dismissed. Trailers are creative, not literal. 43rd. Fired for body odor medical. Sued under disability law. Lost. Workplaces can enforce standards. 44th. A prisoner sued Guinness for not naming him most litigious. Dismissed. Peak FRIVOLOUSNESS. 40-5th. Sued David Blaine for stealing God powers. Tossed. Can't sue for wizardry. 40-6th. Pastafarian sued for colander ID photo. Dismissed. Satire isn't religion. 40-7th. Nutella healthy ads sued. Settled. Must balance claims. 40-8th. Neighbor's parrot harassed with obscenities. Dropped. Bird blame absurdity. 40-9th. Seat belt ticket on a horse. 1. Horses aren't vehicles. Alright, 49 cases down, 1 to go. But before our final exhibit, it's time for the final verdict. The award for the dumbest case that created the most consequential law for the advertising world goes to the man who sued Pepsi for a Harrier jet. Why this one? Because it's the perfect collision of youthful audacity and corporate hyperbole. A kid saw a joke in a commercial and called the company's bluff with $700,000. The resulting lawsuit forced the legal system to draw a permanent crystal clear line in the sand, creating the definitive legal precedent that says an obviously ridiculous joke in an ad is not a legally binding contract. Every over-the-top commercial you see today is protected by the ghost of that lawsuit. Do you agree? Let us know your pick in the comments. And now for our final number, 50. The case that gave us the most important dumb law of the internet age is arguably Blumenthal versus Drudge. In the late 90s, the gossip site The Drudge Report ran a story falsely accusing a White House aide of spousal abuse. The aide sued not just Matt Drudge, but also America Online, the internet service provider that hosted the report. This was a critical moment. If AOL was held liable, it would have meant that every ISP, every forum, every website would be legally responsible for everything their users posted. It would have killed the internet as we know it. The court ruled in favor of AOL, a decision that became the foundation for Section 230 of the Communications Decency Act. This is the law that says online platforms aren't liable for what their users post. It's the bedrock of the modern internet, the reason YouTube, Facebook, and Twitter can even exist. And it was all born from a dumb, false piece of gossip. So, from lawsuits against God to legal battles over sandwiches, it's clear that the path of the law is not always straight. It's a messy, chaotic, and often hilarious reflection of our own absurdity. These cases aren't just funny stories. They are the stress tests that bend, break, and ultimately shape the rules that govern our lives. What is the most ridiculous lawsuit you've ever heard of that we missed? Share your favorite examples in the comments below, because the rabbit hole of legal insanity goes deeper than you can possibly imagine. And if you enjoyed this journey into the bizarre, make sure to subscribe and turn on notifications so you don't miss our next exploration of the world's most fascinating stories.